Honorable, the judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable United States Court of Appeal for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Please be seated. Ms. Walker, it's a little bit dark in here. Do you have any control over the over the lights?
I do not, I will check on that.
Maybe we could brighten things up. All right, let's begin with our first case. Mr. Lindsay, Ms. Lindsay, I'd be happy to hear from you.
Thank you, Your Honors. Good morning, Your Honors, Counsel, and may it please the Court. Jillian Lindsay on behalf of the appellants. We're here to address several errors at the district court level, and these were errors that removed claims, remedies, and evidence from the jury. We ask that this court reverse and remand for a new trial so that the right claims with the right remedies and the right evidence can be heard by a jury to reach the right result. I've divided my argument into 3 parts to assist with the organization today. The first is the ruling on summary judgment in the face of factual issues that would preclude summary judgment and require a jury to decide. The second is judgment as a matter of law being granted when there was evidence for a reasonable juror to find it in favor of Elgin, and several evidentiary rulings that created a distorted and incomplete record for the jury to consider. For those reasons and the reasons we'll address today and in our briefs, we ask that you reverse and remand for a new trial.
Now, you also have a claim that you want another judge. You threw that in there, too.
Yes,
You
Your
didn't
Honor.
mention that.
Yes, Your Honor. That is addressed in our briefs. We have requested reassignment. We understand that is up to the discretion of this court, and that in this jurisdiction that is not the common practice. We have made that request for the benefit of the court and the parties. This was a heavy trial with many, many evidentiary rulings. And with that, we would leave it to the court's discretion, just understanding that is.
I've always found Judge Berger to be a very fine judge and very fair, and I looked over this, and you may disagree with one ruling or another, but that's a pretty tough position to take, that you ask us to have. It's very insulting to a district judge. It implies that they cannot be impartial. And I don't, I'm just speaking for myself, I do not think that's warranted as a general matter with this judge, nor was it warranted by anything in this case.
Understood, Your Honor. And with that, we,
No, but you also did it without specifying any particulars to support it. You just threw it in at the end of your brief. You want another judge. You want a reversal and then want another judge. I was taken aback by it, personally.
it was not our intent to have that impression on the court. We have seen that while it is not the practice here, in some jurisdictions it is.
Did you try the case?
Yes, Your Honor.
So you spent time in the courtroom in Charleston.
Yes, Your Honor.
And you got to know Judge Berger.
Yes, Your Honor.
I really just cannot stress that I do not like that on the changing of the judge, because it implies not only that you think a judge is wrong, but you think that judge cannot be impartial. And that, that insinuates that this judge is incapable of being impartial, and I just want to state my strong disagreement with what you're implying.
Understood, Your Honor. It was not our intent to imply or insinuate anything with respect.
And I'm gonna have to say that I agree with Judge Wilkinson, and I've known Judge Berger personally since she was the chief the chief state prosecutor in Kanawha County where I practiced. And she was a state court judge before whom I practiced. And she was a federal judge, became a federal judge. And she was an assistant U.S. attorney there as well. And I don't think I ever dealt with her that way, but I did get to know her because of her, as a state court judge and as a state prosecutor. And she's about as even-handed as anybody I was ever around. And I probably shouldn't be expressing maybe that strong personal preferences, but I have them. Maybe you can move to disqualify me. But I really think highly of Judge Berger. I'll put that on the record.
Thank you, Your Honor. And to be clear, Judge Berger did an excellent job preserving the record in this case. We understand and appreciate that she has had a distinguished and esteemed career, and we did not mean to imply anything about her qualifications, ability, or potential bias by asking for this request. It was indeed a combination of practices in other jurisdictions where you've seen this and the extreme heavy load that this case took on. It was a multi-week, heavy evidence case with hundreds of documents being moved to seal, and we would just like to reiterate that we do not intend to imply or suggest anything with respect to Judge Berger's ability to remain impartial or her ability in making that request. With that, Your Honors, I'd like to move on to discussing the summary judgment ruling. On summary judgment, there are 3 independent reversible errors. Agreeing on any one of these errors would warrant reversal of summary judgment. The first would be that an issue of fact precluded summary judgment, and the district court failed to address and consider the complete facts in its analysis. Now, that factual question is whether or not the restrictive covenants at issue were ancillary to the sale of a business. As I'm sure this court is familiar, Mr. Dillon sold his business to Elgin's predecessor in November of 2013, and in that sale signed a purchase agreement and an employment agreement, both of which contain restrictive covenants. Now, we know this is a question of fact because it has been discussed as an issue of fact in several cases, and we would point you to the Palmer decision out of the 11th Circuit. And in this case, the facts that support that this was ancillary to the sale of the business and presented on summary judgment were the asset purchase agreement itself lists the employment agreement as a necessary document for closing, meaning without that employment agreement, the purchase agreement would not have been closed. Mr. Dillon admitted in his deposition that Elgin wanted to acquire his business and grow it with him at the helm. One of the assets considered in this purchase was Mr. Dillon's continued leadership and role within the company. The covenants at issue run from the same date. They both run from November 13th, 2013. That is the date of the sale of the business. That is when the covenants in both the purchase agreement and the employment agreement start. These documents were signed the same day by the same parties represented by counsel in the same meeting. This was one integrated deal. Unlike some of the cases at issue in the briefing, Mr. Dillon had complete bargaining power on his side of the deal. He was the sole owner. Mr. Dillon could decide whether he wanted to agree to these terms or not. He was not carried along as a minority owner or a stockholder or even a Class B owner of interest that you might see in an employment context. He was the owner of a business selling it to Elgin and making promises in connection with that sale and securing the highest possible price, a cash price of $3.47 million in exchange for those promises. This was an integrated deal that the parties entered as one.
But all of this doesn't mean that I'm not sure how that affects the question of the breach of the restrictive covenants, because I understand you say, well, he agreed to those as a matter of contractual negotiations, but isn't it also a significant issue of West Virginia public policy? Doesn't the West Virginia Supreme Court take a dim view of overly broad non-compete agreements?
Your Honor, that's an excellent point. We would point also to the fact that the wrong law was applied under the party's choice of law. And with respect to West Virginia, it may have a willingness to examine these agreements more closely than Delaware, the choice of law that the parties selected in their contract and freely chose. But there is no fundamental public policy in West Virginia that says these non-competes or restrictive covenants cannot be upheld, especially in the sale of a business context. They are more freely upheld. With respect to the choice
This one seemed to me to be extraordinarily broad. It spanned more than a year, and that it covered the entire United States. I haven't seen these non-compete agreements. We see a lot of them up here, and I haven't seen many of them that are as broad as this one, and I just don't know what interest was served by preventing this individual from competing anywhere in the United States, because Elgin's business didn't extend to the entire United States. And why was it necessary to go on for more than a year? Most courts think non-compete agreements that extend for more than a year are too long.
Your Honor, there are a few points I'd like.
This is a very aggressive non-compete agreement.
If I may respond first to your point with respect to time. The non-compete and restrictive covenants in general apply for the time Mr. Dillon worked at Elgin and for 1 year thereafter. Not just 1 year, not beyond a year. Also, on its face, it only applies absent written agreement from the parties to do something else. And that's what we saw here. When Mr. Dillon gave notice that he wanted to slow down, have better work-life balance, open a small repair shop, Elgin agreed to allow his non-compete to run in tandem with his continued employment, a period when he received his complete salary, complete benefits, and retained the title of president. So when you look at how this played out and what the parties' agreement was in fact, and at the summary judgment stage, the way it should have been assessed, had Mr. Dillon honored those.
Your basic argument is that he contractually agreed to this, correct?
That's one argument, yes, Your Honor.
All right, and what I'm saying is that that carries you a certain distance. But when you have something that both in spatially and temporally is very, very broad, doesn't West Virginia policy enter in, not in a marginal case? I would think that the freedom of contract argument would prevail, but I'm not sure whether it prevails in a situation where you have a non-compete that goes on for as long as this one, or it extends as widely as this one. In other words, I think it's a legitimate point to make that this is a freedom of contract. There's a freedom of contract question at the bottom of it, and I think that carries you good ways, but I don't think it allows you to put things in that disadvantage somebody from competing. At some point, West Virginia public policy, which has been expressed repeatedly in that state, that would seem to me to be controlling.
And, Your Honor, if this contract was looked at pursuant to the sale of a business, it would be clearly upheld under West Virginia law. If this contract is viewed under Delaware law, the party's choice of law, it would be upheld. And the facts as they stand, with only 2 months remaining on the restricted time period after he leaves Elgin's employment, and a factual dispute as to Elgin's reach for the business. There was evidence in the summary judgment record to support a nationwide reach, both with respect to Elgin delivering machines nationwide and efforts to market nationwide. And we see in the case law that having a facility in each state is not the requirement. In today's modern world, national non-competes have more and more import as we are working on the internet and servicing clients from further distances. The key test is if there is a reasonable relationship to a legitimate, protectable business interest. And to protect Elgin's business interest from the exact threat that Mr. Dillon posed, this covenant was reasonable. It not only mapped the work that Elgin does, but it mapped the work that that Mr. Dillon did with Elgin's clients for big companies like Dubs and Darling Ingredients, which were serviced nationwide. And with the only 2 months that remained on the non-compete, had he honored it, a nationwide geographic scope is certainly reasonable for that short amount of time.
Well, these non-compete agreements, in addition, as a matter of West Virginia law, they, by their very name, suppress competition. They do two things. Number one, they disable a person from taking his own business initiatives and starting up a business of his own. He's prohibited from doing that, so you're disabling a person in that sense, and you're also suppressing competition. And competition is generally thought from a standpoint of a consumer to be a positive benefit.
Your Honor, I see that I'm out of time. May I answer?
Well, why don't you, if my co-panelists have a question for you, that's fine, but otherwise, you've got some time for rebuttal.
Understood.
Bob, do you have any questions?
I'm fine.
Roger? We don't have any questions. We do have some rebuttal time, okay?
Thank you, Your Honors.
Mr. Harvey?
Good morning. May it please the court. My name is Shane Harvey. I'm here with my law partner today, Grace Herney. We represent Chad Dillon and his company, Dillon Industries, and we did so at trial. Unless the court has a different preference, I will try to address briefly each one of the arguments that Elgin made in its brief in the order it made them. Starting first with this issue of the restrictive covenants. Judge Wilkinson, as you appreciate, restrictive covenants are disfavored. Courts do not, and this is true in every state, courts do not like to deprive employees of the ability to make a living, and they understand that employers and employees often have unequal bargaining power. So they are reviewed strictly in every state, in particular West Virginia. There is an exception, as Judge Berger recognized, for covenants that are ancillary to the sale of a business. In that case, courts will sometimes apply a more liberal standard under that situation, understanding that the parties may have more equal bargaining power.
And this is one of these circumstances where it is in connection with the sale of a business, correct?
It is in part, Your Honor, but I want to be very clear about this. The circumstances we have here in this case, no court has found a covenant to be ancillary to the sale of a business in a case like this. And let me explain what I mean by that. Here we have two agreements, an employment agreement and a sale agreement. Both contain restrictive covenants. And this is critical. The restrictive covenants in each agreement are different from one another. If you lay them side by side, they have different language, they have different definitions, and they run for different lengths of time. To anyone reading these contracts, it is apparent that each covenant was drafted for the agreement that it resides in. That is, the covenant in the employment agreement was drafted as ancillary to employment, and the one in the sale agreement is drafted as ancillary to the sale. And yet Elgin urges this court, and they urge Judge Berger, to treat both covenants, which are different from one another, as ancillary to the sale, and neither is ancillary to employment. No court has ever done this. And in fact, courts have expressly rejected the approach Elgin suggests here today. If I may, there's one case that's directly on point in this regard. It's from the Court of Appeals of Georgia. And here's what it has said about this precise issue. This court has consistently held that when parties execute separate contracts for the seller's sale of the business and the seller's subsequent employment, and each contract contains different restrictive covenants, the restrictive covenants in the employment contract are subject to strict scrutiny. Hilb versus Holly, 644 Southeast 2nd, 862.
Well, let's assume that in your argument that they should be taken in tandem. So let's look at employment. What is wrong with that one in terms of, because both sides were represented by counsel, correct?
Both sides were represented by counsel.
So tell me what it is about that. I'm accepting your argument that it should not be considered in the same context with the sale of a business. So let's say it's separate as employment. Go ahead.
Yes. This contract, to the extent we're considering it ancillary to employment, Judge Gregory, is, as Judge Wilkinson recognized, very broad. It is very similar, almost identical to covenants that have been rejected by other courts, including in West Virginia, as overbroad.
It is overbroad because it's too long?
The one-year provision is...
1 year is certainly not overbroad, is it?
1 year is not overbroad. And Judge,
tell me what part is overbroad.
the geographical extent of it, Your Honor.
What's your response to counsel's argument? And it seems rather plausible to me. But we live in a world, as Tennessee Williams said in the Glass Menagerie, blow out your candles because the world is lit by lightning. I mean, now people, just by internet, you're just all over the country. It's seamless, isn't it?
Judge Berger understood this, Your Honor, and specifically addressed it in her opinion. She recognized that it can be appropriate to have a...
Why is it not appropriate here?
Because Elgin did nothing at summary judgment stage, Your Honor, to demonstrate that its business was truly national or international.
Well, you don't have to, do you have to prove what the business is? The question is whether or not it's unreasonable in the context of the language in the contract, not whether they have to prove it. Like, you almost say, well, you know, I understand, why did you sign that contract? What were you thinking? No, that's why we look at the language. Tell me about the language, why that's unreasonable.
The language, Your Honor, essentially makes Mr. Dillon unemployable and deprives him of the ability to make a living.
For how long?
For 1 year. And it prevents him from directly or indirectly competing, which is very confusing.
You said a restriction of 1 year of competition against an employment situation, that's unusual?
The 1 year itself is not...
Not at all.
And I would concede that point, Judge Gregory, but combined with everything else, 1 year nationally means that Mr. Dillon cannot go anywhere to work across the nation for an entire year. That is not reasonable under the law.
He can go to work. He just can't be in the context of competing using information that he would know from that. It's not, you can work. It's not a restriction that you can't work anywhere. So right? Am I wrong about that?
He cannot use his lifelong trade, Your Honor, which is...
Because that's what he saw. That's why he got $3.47 million. I mean, in other words, that's what you paid for.
If I may, Your Honor.
Yeah, go ahead. You may, but I may answer my question.
The $3.47 million was under the sale agreement. And what the parties agreed to in the sale agreement is that he would not compete for a period of 5 years. That period expired. That is what the parties carefully agreed to and crafted is, for the sale of this business, Mr. Dillon, you will not compete with us for 5 years.
I would think that if there were trade secrets used or confidential information used, that would be a separate claim from the question of the temporal and spatial breadth of the covenants themselves. I mean, I think, I guess your argument isn't the question of the breadth of the non-compete agreements separate and distinct from the question of whether there were trade secrets or confidential information used.
Yes, Your Honor. The agreements had nothing to do with the trade secret issue. The trade secret elements are different.
Because what
They're-
the non-compete agreements are saying that he can't even compete using legitimate methods.
Correct, Your Honor.
And that's part of the breadth here, is that no matter how legitimate his business decisions were, and no matter how he went about his business, that would be banned.
Correct, Your
and,
Honor, correct. They are,
But that doesn't foreclose counsel from saying, well, yeah, you can compete, but you can't use this confidential information and this and that. But I just see that as a different issue from the breadth, because the breadth of it, it says, you know, we don't care whether you're using legitimate methods or not, you can't compete. And West Virginia doesn't like that.
correct, Your Honor. There are three covenants at issue here. There's a non-compete covenant, there's a non-solicit covenant, and there was a covenant to keep information confidential. That one was boundless in terms of time. It applied forever, and it was found by Judge Berger to be overbroad, relying on other decisions in West Virginia saying just the same. It prevented him from using information directly or indirectly for the rest of his life that he learned at Elgin, and essentially made him unemployable, was Judge Berger's ruling, and I think it was the correct one.
Well, this seems like a contract where you, the person's retiring, doesn't it? I mean, you read the contract, it's one where you say, okay, I'm getting 3.47 million, because the way the terms are, you know, it's like, you know, you're gonna go off and, you know, enjoy yourself in the sunset, right? That seems like to me what it is. And
It's
if you're not gonna do that, it's a contract maybe you wouldn't wanna enter into.
It's probably what I would have done, Your Honor, after receiving that amount of money, but I think in this case that Mr. Dillon and Elgin agreed that they needed him for two purposes. They needed his business, and they paid a fair price for that, and he agreed not to compete for 5 years. They also wanted him to stay on as an employee, and he wanted to stay. And they negotiated a separate agreement for that purpose that had the 1-year provision we're talking about, that after leaving for 1 year, he cannot compete. And I want to make it clear, this is not a case where someone sold their business and immediately double-crossed the purchaser and went out and began competing. Mr. Dillon stayed for 9 years. This covenant was entered into in 2013. He didn't leave until 2022. He was a loyal employee the entire time. The 5-year term for the non-compete expired. There was no unfairness here in any way. And I also,
Opposing counsel's argument is that you received a pretty nice hunk of change with $4 million plus, and part of what they were bargaining for was their right, as they see it, to be free from competition for a certain amount of time. Now, so does it make a difference here that they see it as a bargain for the non-compete is simply one other thing that was on the table, and it was a bargain for benefit? In other words, if the fact that the non-compete agreement is a product of a carefully negotiated contract, does that put it on a different footing from a non-compete agreement, which is just imposed on an employee who has very little bargaining power? What they're saying is that he had bargaining power, and what was bargained for was the non-compete, and you don't have that in a lot of situations where, as a part of the employment contract, the non-compete agreement is part of the employment contract, but you don't have any kind of equality of bargaining power in that situation. So just tell me what your response is, because non-compete agreements arise in different contexts, and some of them are just imposed right at the outset, but that's not the case here. And so tell me, does that make a difference in your view? What's your thought about that?
Yes, Your Honor, I understand your question. And the important point here is that we have two agreements. One covers the sale and one covers employment. And they're both judged by different standards. And the one that covered the sale did have a bargain for provision. He received $3.47 million for the purchase of the business, and in exchange for that, he agreed not to compete with this company for 5 years. He honored that, and that provision expired. The only reason we're here is because that provision expired, and now Elgin wants to take the provision in the employment agreement and apply that as if it was part of the sale agreement. And the employment agreement must be read strictly, Your Honor, for all the reasons you've recognized. West Virginia policy and the policy of other states disfavors these very broad employment agreements in situations like this when they deal with the issue of employment. So it's two different standards. The sale agreement has to be judged by the liberal standard for agreements that are ancillary to the sale, but the employment agreement must be judged by the more strict standard reserved for strict scrutiny of employment agreements.
Now, what y'all been talking about here all dealt with the pretrial rulings made by Judge Berger,
Yes, Your Honor.
correct?
Yes, Your Honor.
And there was a jury trial.
Absolutely, Your Honor.
And at the jury trial, you lost.
Well,
There was a verdict for $11,000.
we lost on one issue, yes, Your Honor.
Pardon?
We lost on one issue, the fiduciary duty issue, yes,
You
Your Honor.
lost a verdict.
Yes.
Did anybody challenge that verdict? Is that contested in this appeal?
We have not challenged
You
it.
didn't cross appeal?
No, we did not cross appeal, Your Honor.
Okay.
They have challenged it, and I think their argument is
They're
essentially.
challenging a verdict that they won.
Yes, Your Honor. As well as the
Is
trade.
that, can you do that in the federal court?
Well, I think their argument is they lost on the trade secret claim, and they're challenging that. The other claim was a fiduciary duty claim, which they won on, but only to the tune of $11,000, to your point, Your Honor. And I think their argument is essentially that amount might have been greater if some of these evidentiary objections had gone their way, if Judge Berger, in their words, had not erred, is their position.
But there's been no appeal lodged specifically as to the verdict, or has there?
I don't know that their appeal goes to the size of the verdict so much.
But you don't challenge the verdict?
Absolutely not, Your Honor.
And you lost the verdict?
Correct, Your Honor.
All right. See, I thought appeals were for losers. That's what I always kind of thought.
That is normally the case, Your Honor, yes. I see I've got 20, I'm over time, actually. Does the court have any more questions that I can help with?
Judge, do you have any? All right, thank you.
Thank you very much.
May it please the court. My name is Scott Kaminsky, and I'm here today on behalf of Don Ritchie, who was an employee of Elgin and then later Dillon Industries. Your Honors, Judge Berger got her ruling with respect to Mr. Ritchie exactly right when she granted judgment as a matter of law at the close of all of the evidence in his favor as to Elgin's breach of duty of loyalty claim. And the reason that Judge Berger got this ruling exactly right was that Elgin failed in one of the critical elements of that claim, that being damages. As we all know, a plaintiff must prevail on all elements. And what Judge Berger's narrow ruling said was that the proof that was put forth by the plaintiff would lead a jury only to speculate as to the damages it might award if it did find that Mr. Ritchie breached his duty of
Well, the
loyalty.
jury could extrapolate, couldn't they? Since, well, the evidence was, well, he worked that many times. The allegation, of course, is just using that time for another purpose. So you say, over what period of time, and that kind of thing, so why couldn't they estimate that? You're saying that they have to quantify it to the points that these are how many hours he was engaged allegedly into this, and a jury couldn't do that?
I think that's right, Your Honor, and the reason is this, is that at trial, Elgin didn't attempt to quantify that period of time. They didn't take the emails that they put into evidence and say that this email was sent at this time and responded to at that time and add those up. They didn't even attempt to do that. In fact, in their briefing, they admit that the time that Mr. Ritchie spent working for Elgin but assisting Dylan was de minimis. And so.
Did they use that word, or did that?
It's in their brief, I believe, at page 9.
They said it was de minimis.
De minimis, de minimis.
Which could be nominal damage.
It could be nominal
And
damage.
do you think the jury could give nominal damages?
The problem in this case, Your Honor, is that no evidence was put before the jury as to what those nominal damages might be. There was no
evidence of how much money he made his salary?
That's it. That's just the point, Your Honor. The only evidence before the jury was Mr. Ritchie's entire salary for 2022 and his overtime pay for 2022. But there was no evidence put forward to the jury as to what period of time Mr. Ritchie was disloyal, if at all, and therefore no way for a jury, as you suggest, Judge Gregory, to extrapolate that. It would have been speculation, and that's why Judge Berger was exactly correct. The plaintiff called an expert witness, Morgan Winfrey. He testified on my cross-examination that none of his calculations with respect to lost profits were attributable to Mr. Ritchie, so that item of damages is out the door. And he testified that with respect to disgorgement, that he did not calculate the amount of time that Mr. Ritchie was disloyal, nor did he put forth any period of time for the jury to suggest that this is the period of time of disloyalty. That would have been a perfect opportunity for a hypothetical question by plaintiff's counsel to Mr. Winfrey. Mr. Winfrey, if the period of disloyalty began on this date and ended on this date, what portion of Mr. Ritchie's income ought to have been disgorged? And that was never put before the jury. There was no evidence before the jury that Mr. Ritchie was disloyal, if at all, for the entirety of 2022, nor that he was disloyal, if at all, for the period of time of overtime that he worked in 2022.
But there was evidence that he was disloyal during the time that he was paid.
I would disagree with that respectfully, Your Honor.
That was a question. I didn't make a statement. But was there?
I don't believe there was.
But you just said, they said he was doing something. Didn't they say that he was engaged in activities that was not in the interest of the people who were paying his salary?
That is true, Your Honor.
All right, so that means that it takes time to do something wrong, all right. So there's evidence that while he was being paid, he was engaged in conduct that he shouldn't have been involved in on their allegation.
Correct, de minimis, but
Well,
correct.
that's what extrapolation is. They say, well, you're getting paid, and they knew how much money he made per year.
That's correct, Your Honor, and they knew, what they knew was what he made in 2022. That was the evidence before the
And
jury.
they didn't say what month he did this or how, at all.
That's correct. They didn't tell,
Nor how long it took any one activity to do.
that's
to
correct, Your
accomplish.
Honor. Yes.
Okay.
I see that I'm out of time, or there,
That's all right.
You okay?
I'm fine.
You have any further questions?
thank you, Your Honor.
Thank you. Ms. Lindsay?
Thank you, Your Honors.
Counsel, I know you don't have much time, but could you just answer a question to follow up? You didn't put any evidence in that a juror could extrapolate from what he was doing that you allege he did from a time standpoint?
That's incorrect, Your
Okay,
Honor.
I didn't think it was, but go ahead.
The evidence in the record that the jury should have been able to consider included time-stamped and dated text messages sending from Mr. Dillon to Mr. Ritchie asking for work while Ritchie was on the clock. emails, time-stamped and dated, of Mr. Ritchie responding to those requests the same day on the clock, sending the requested information. They show purchase orders, drawings, Elgin's engineering drawings that merely have Elgin's name removed and Dillon Industries added. The entire file share link for our 24 by 60 machine, the most popular machine used by our most important customer, JG, who has national reach. We showed that those drawings, that link sent during working hours, led to Mr. Dillon securing over $1 million of work from JG in the first month of operation, work that he admitted he could not get without our drawings, without that information. And the restatement is clear. Our damages against Mr. Ritchie are not cabined by just what exact minutes is he being disloyal. You also look at the harm to Elgin. And Elgin's foreseeable harm was tied to that lost profits analysis. And in the same morning, just minutes before the district court ruled on a very extreme judgment as a matter of law, high standard, saying no evidence, the jurors shouldn't hear this, she also denied a motion to strike that testimony from our expert, saying that this lost profits analysis is too speculative. She found it was not speculative and would go to the jury. You can't reconcile those two rulings on their face. And while there's claims that our damages expert didn't speak specifically to Mr. Ritchie, our damages expert did what damages experts do: calculate the numbers, calculate the harm, assume complete liability, no comment as to causation, but lay out Mr. Ritchie's compensation, Mr. Dillon's compensation, which the jurors should have seen, laid out lost profits, which the court ruled were not speculative and appropriate for the jury to consider. But nevertheless, those claims were taken away from the jury with respect to Mr. Ritchie.
You have 7 different claims here, or maybe it's 8, I'm not sure. Do you think you might have been better off concentrating on one or two things which went wrong, rather than throwing 7 different claims against the wall?
Your Honor, I appreciate that comment. And what our claims show is a cascading effect. If you look to the ruling on summary judgment that takes out these provisions that are ancillary to the sale of a business, issue of fact for summary judgment, and I just want to point out that Weaver, a case in West Virginia, upheld a 15-year restrictive covenant non-compete in the sale of a business. And there are several cases that uphold this tandem integrated approach to covenants. With that error of taking that claim out of the case, that leads to the errors in the evidence. Because those documents that show Elgin's efforts to safeguard its information, those were necessary to prove a prima facie element of our trade secret claim. We could not even show the jurors the clear promises Mr. Dillon made day one to protect our information, and we had an obligation to show reasonable efforts to safeguard. We didn't have a shot of proving our trade secret claim without having those documents at play. If those documents had been at issue, there was no issue of confusion, and those documents should come in. You can see it as a domino effect or a cascading effect. With respect to the Rule 50 motions, again, a very, very high standard to take a claim away from a jury. We see evidence that the jurors should have considered, that they could have considered in reaching and finding a reasonable verdict against Mr. Ritchie, who spent time on the clock at Elgin. Now, whether we do not say that the time is de minimis, that was an argument that was made by the other side, but regardless of whether that time is de minimis, the harm, the actual harm to Elgin is not de minimis. It was millions of dollars. Their business was gutted. All of their drawings were taken, hundreds of thousands of drawings. Mr. Ritchie made 19 different storage devices of our information, stole 11 employees, and as a result, Elgin was harmed. The jury should have heard those claims. I see that I am out of time, Your Honors.
Well, we thank you very much. Judge King, you okay? You're fine, thank you. We appreciate all of your arguments, and we'll come down and greet counsel and then proceed directly into our next case.
Thank you.
Here to hear argument in Cerritos versus Blanche.
Good morning, Your Honors, Counsel. May it please the Court. I'm Dree Colopy, an attorney of record for the petitioner and a supervising attorney in the American University Washington College of Law Immigrant Justice Clinic. I am honored to introduce Andrew Porter and Mackenzie Stoker, students in the clinic who are appearing today under Local Rule 46A. With the Court's permission, they will now present the petitioner's argument.
Permission granted.
Thank you.
Good morning, and may it please the Court. My name is Andrew Porter, representing petitioner Jaime Daniel Navarro Cerritos. I will be discussing the jurisdictional and timeliness issues, while my colleague Ms. Stoker will handle the merits of Mr. Navarro's claims. This case is about a petitioner who diligently exercised his procedural rights as they existed at the time. Despite this, the government is seeking to deny him his day in court, imposing jurisdictional requirements where there are none to chip away at judicial review for non-citizens who cannot challenge their removability, but who wish to seek review of their CAT and withholding-only claims. Neither the statutory text, congressional intent, nor the Supreme Court jurisprudence limit review in the way the government would have you do so today. First, this court has jurisdiction over Navarro's petition. There is no jurisdictional requirement to challenge removability. Second, although Navarro's petition is untimely post-Riley, 1252b1's 30-day deadline can and should be equitably tolled. There is no jurisdictional requirement to
Well,
challenge.
even if we possess jurisdiction, that doesn't relieve you from the burden of indicating that the relevant statute and rule permit equitable tolling.
That's correct, Your Honor, and I can jump to that.
So you've got the jurisdictional argument is one thing, but you've still got the statute and the rule to contend with.
Yes, Your Honor. There are two layers to get through today. And if you please, I can jump straight to the equitable tolling. The statute itself, 1252b1, is subject to equitable tolling. Post-Riley, the court held open the opportunity to apply the presumption for equitable tolling that the Supreme Court established in Irwin. That is a rebuttable presumption that can only be rebutted by the statutory text and the statutory scheme themselves. Here, the statutory text is no more mandatory than a series of statutes that this court has applied equitable tolling to.
I think that the difficulty that you have here is that you have to contend with the combination of the statutory text and Federal Rule 26. I think it's the combination that makes things particularly tough, because you could say, well, there's a rebuttable presumption in favor of equitable tolling under the Irwin case, but when you combine the very clear, direct language of the statute with the wording of Federal Rule 26, it's that combination of things that expresses a congressional intent that's hard to overcome.
Well, we respectfully disagree that Rule 26 really plays into this at all. The nutraceutical case that the government cites has never been extended to the statutory context. In nutraceutical 26b1, a separate Federal Rule of Appellate Procedure singled out Federal Rule of Civil Procedure 23F for singularly inflexible treatment. Here, 26b2 makes no mention of 1252b1's 30-day deadline, and also... How
do you deal with, because we've had a number of these cases, and we have in innumerable cases, I mean, I agree they were unpublished decisions, but in case after case after case, we've declined to extend the period because of just the textual wording of Rule 26 and the statute. And the particular thing that's hard, I think, for you to overcome is the language that the court may not extend the time to file unless specifically authorized by law. Unless specifically authorized by law. And then when you look at the wording of the statute, which says that it must be filed no later than 30 days after the final date of order of removal, that is the exact opposite of specifically allowing and authorizing something by law. In fact, it doesn't. It's the exact opposite. It says no, it's far from authorizing something by law, it says it must be filed within 30 days. And so I don't know how you get around the fact that this rule says specifically authorized by law, and not only is there no specific authorization, but there's a clear requirement using the word must.
Yes, Your Honor. So,
That's just tough.
yes, Your Honor. So 2 points to address that. First, the specifically authorized by law exception includes the application of equitable tolling. Equitable tolling is, that presumption is read into the statutes as though it were the text of the statute itself.
Where is the specific authorization by law? Where is the authorization by law? We just can't blow by the statutory language that's as clear as this.
Well, the language of 1252.
But could you just tell me where the authorization is?
The authorization is the equitable tolling principle that is read into the statute. The text itself that says
No,
must be.
tell me from the statute. Where is the authorization in the statute? It says it must be filed no later than 30 days, and they can, they can extend that, but as I say, we've had, I think, 3 or 4 decisions that have raised this very question, and in each case, we've declined to extend the time because of this language.
Yes, Your Honor. The language in 1252B appears pretty, stringent in terms of must, but this court in Williams and in Cusk applied equitable tolling principles to statutes that said motions to reconsider must be filed within 30 days, no exception written into the statute. And in Cusk, they said motions to reopen shall be filed no later than the amount of days required there. So those statutes did not require exceptions. The equitable tolling principles were read into the statute as though they were the text of the statute themselves, and thus that fits into
But that reply that you've given me, you're asking us to read into the statute things that aren't there.
Yes, Your Honor, that's the kind of how the application of equitable tolling to statutory requirements works. That's how it's applied.
But you say, you just use the word implied. Mm-hmm. But that's not what, the language of that rule is specifically authorized. It's the exact opposite of implying provisions in statutes. And then you have the Supreme Court's decision in this, I guess I have a hard time pronouncing it, I must say, it's nutraceutical or whatever it is. Mm-hmm. And it says, whether a rule precludes equitable tolling turns on whether the text of the rule leaves room for flexibility, and so whether pertinent rule or rules invokes show a clear intent to preclude tolling, courts are without authority to make exceptions merely because a litigant appears to have been diligent. I may not agree with that, but it seems to say, stop implying things in the face of the specific authorization language. That just, you know, basic 1A maxim of law.
Well, respectfully, Your Honor, nutraceutical is talking explicitly about rules of civil procedure, rules of federal appellate procedure. The principles of nutraceutical have never been extended to the statutory context where there is this equitable presumption for tolling. As the DC Circuit in Nelson v. SEC noted, nutraceutical has never been extended past the limited application to 23F, which was singularly pointed out for inflexible treatment. So here we have this equitable tolling principle that's read in because that's what we have to look at. We have to look at whether Congress, and Your Honor, I see my time's expired. May I briefly answer this question, or?
You've certainly got some rebuttal here, but why don't you make these points in rebuttal, and in the meantime, my co-panelists have questions, stay up there until we know. We also want to hear from Ms. Stoker. Do you have any further questions of this gentleman?
Have you made your best argument that equitable tolling applies?
Well, I think one thing that has not come up is that the scheme, which is the decisive factor in whether equitable tolling applies, the scheme of the statute, the Supreme Court in Enbridge just identified that as the most important part. Here we have a very simple scheme with not very many exceptions at all held throughout 1252b1 and 1252 more broadly. It's very dissimilar to Ariana, which had 16 exceptions, and Enbridge, which had 6. This is not a highly detailed statute. It's aimed towards litigants and non-citizens who lack legal knowledge, which furthers the presumption that these unsophisticated claimants are subject to the equitable tolling, as the Supreme Court stated in Auburn Regional Medical Center. And thus our petitioner filed his petition under the law as it existed at the time, pre-Martinez and pre-Riley, and these changes in law he could not have foreseen. The government makes much of his ongoing awareness of the oral arguments in Martinez, but the government itself didn't know what constituted a final order and when the timeline started at that time. He exercised his rights as they existed at the time and complied with this court's requirements to seek review. If there are no further questions.
You okay?
Yeah.
Judge?
Well, doesn't Riley help you in a sense what the court did? It sent it back to us, didn't it?
Mm-hmm. Yes, Your Honor.
So there's nothing else to do. Supreme Court said it was something else to do.
Yes.
It's not jurisdictional. Yeah. And follow up to Judge King's question, there's some more arrows in your quiver, aren't there?
Yes, Your Honor,
didn't talk about
absolutely. So in Riley, Justice Sotomayor in her dissent explicitly said that this statute will now have to be analyzed by courts of appeal to determine whether equitable tolling applies. It's no longer jurisdictional, and courts have never analyzed whether it was mandatory because courts typically took the jurisdictional and mandatory language to mean the same thing in the past. So now we have this new world where we get a chance to read in these equitable principles as Congress intended to protect the rights of non-sophisticated claimants who could not have foreseen these drastic changes in the law.
You have further questions?
Okay. Thank you, Your Honors.
Ms. Stoker, let us hear from you.
May it please the court, my name is Mackenzie Stoker, and I'll be covering Mr. Navarro's merits claims. This is a case about a man who has been continuously assaulted, threatened, and harassed by MS-13 since he was approximately 8 years old. Mr. Navarro respectfully requests that this court reverse the agency's decisions and remand with instructions to fully consider the evidence in the record for the following 3 reasons. First, the agency erred in determining that Mr. Navarro had neither an actual or imputed political opinion. Second, the agency erred in determining that Mr. Navarro's PSG wasn't cognizable. And third, the agency erred by failing to provide reasoned explanation and properly weighing both the country condition and the expert evidence in the record in determining that Mr. Navarro is not at risk of future torture if returned to El Salvador. Moving first to Mr. Navarro's political opinion claim. The agency erred in determining that he had neither an actual or imputed political opinion because it reduced his anti-gang activism to a single refusal to join MS-13 when he was approximately 8 years old, and ignored the replete evidence in the record that Mr. Navarro worked with youth to help them avoid gang recruitment by MS-13 when he returned to El Salvador in 2016. It also ignored the evidence in the record regarding Mr. Navarro's actions with the youth committee in El Salvador to help the youth get away from potential gang life and avoid gang recruitment. The agency also erred on Mr. Navarro's political opinion claim by characterizing MS-13's persecution of Mr. Navarro simply as a personal dispute between Mr. Navarro and Vallecios, the landowner that donated the land that was used for the soccer field for the youth committee. Both the IJ and the BIA ignored the important timing of the persecution that happened with Mr. Navarro and MS-13 upon his return to El Salvador in 2016. The MS-13 already started persecuting him again and assaulting him again, calling him things like the new shepherd, referencing his work.
The question here is the nexus.
Yes, Your Honor. So
Isn't that a factual question?
no.
Question, isn't that subject to a substantial evidence review?
No, so the issue with the nexus here was that the IJ and the BIA applied the wrong legal standard when determining nexus.
Well, I don't understand that because the wording in the statute is because of, or on account of. Those are the words that suggest a nexus.
Correct, Your
And
Honor.
the agency in this case made a decision regarding the nexus. And it was factually based. For example, the agency noted that the individual here had not participated in any anti-gang demonstrations, given no speeches, there was no advocacy and everything. And so that was a very fact-specific decision with respect to the nexus question that the agency reached. And I would think that I don't see how we get around the nexus question, around the substantial evidence standard of review. And then there's the additional question of the particular social group. That has 2 problems. One is it's an exceptionally broad definition that could conceivably cover anything from jaywalking to murder. The other problem is that there's no evidence put on, or certainly not persuasive evidence, that that Salvadoran society regards this as a particular social group. And we've said time and again that in order for something to qualify as a particular social group, there has to be evidence that the society regards it as such. And you don't, that evidence is simply not present here, and I don't think it was presented.
We disagree, Your Honor. So part of Mr. Navarro's argument with the errors that both the immigration judge and the BIA made regarding.
What I'm suggesting is that I think you have multiple hurdles dealing with the question of whether this is a particular social group, number one, and number two, you've got a problem with nexus. And so there's one degree of, sort of one hurdle after another sequentially to overcome.
Correct, Your Honor. The evidence on the record regarding the PSG's social distinction shows that Salvadoran society had laws in place to protect people who had witnessed crimes, as well as the gang code.
But report could cover anything. And the connection with respect to MS-13, that could cover anything. I mean, is the connection that somebody's supposed to be a gang member, or is the connection that simply they knew somebody, or I don't know, and you know, what qualifies as a report, but mainly with respect to the particular social group, is this recognized as such in the country itself? And there's no evidence of that Salvadorans regard this as a particular social group. But at any rate, maybe my co-panelists have a question. Bob, do you have any questions? Roger?
Yeah, Counsel, you have a cat claim, correct?
Correct, Your Honor.
You don't have to show a social group for that, do you?
No, you don't, Your Honor.
Exactly. You don't have to have a, right. And in this case here, in terms of nexus, the question about in terms of, you can't generally say, well, the gangs are there and I'm fearful I had some encounter, because then you would need some evidence as to what connects you, the nexus to that fear to them. This case is on steroids in the sense of that.
Correct,
The
Your Honor.
man was raped.
Yes, Your Honor.
He was raped and specifically and accused of killing one of the leaders of the gang.
Correct, Your Honor.
What nexus could there be more than that? This is not one where say, I mean, I read the newspaper, these people are dangerous. Nobody's come to me yet, but I want to lead the country. That's where you need some nexus. But here, my goodness, it is atrocious. Absolutely. So, and the record is replete of that in this case.
Correct, Your Honor.
Is any credibility finding against that said that didn't happen? I mean, for the government?
So in
He
the-
was found credible,
Yeah,
wasn't
he was found credible.
Correct, he was, Your
Yes,
Honor.
that's the answer to that question.
Yes.
Okay, that's all I have. Thank you.
Great.
Thank you.
Judge Wilkinson.
Awesome. Thank you, Your Honors.
Mr. Privy?
May it please the court, Christopher Privy for the Attorney General. This court lacks jurisdiction because the petitioner did not challenge a final order of removal in his petition for review. The petitioner agreed, in fact, in his 28J letter responding to the government's 28J letter on Navarrete in the Ninth Circuit, that a final order of removal must be challenged in order to have jurisdiction in this court. And as Riley has said, a decision out of withholding only proceedings is not a final order of removal. That's the only thing he's challenged in his petition for review. That's the only thing this court needs to find, is that he has not challenged a final order of removal, and therefore this court has no jurisdiction under
Isn't that really a challenge, the removal?
I'm sorry?
Isn't that a challenge to the removal in a sense? Because the removal would be to El Salvador, right? Correct?
He does not challenge the fact of
No,
removability.
No, I'm saying, no, it's not a trick question. I'm just saying, the removal as it stands would be to El Salvador, correct?
He challenges the country to which he would be removed.
Yes, but if he didn't challenge it, he'd have to go to El Salvador.
If that's where the government chose to remove him, yes.
Right. So withholding allows him to have some option to go someplace else, doesn't it?
If he Yes,
So that is a sense, it is a somewhat, it's a challenge to his removal.
No,
Some
Your Honor.
Aspects of his removal, the order, because the order says you go to El Salvador.
No, Your Honor. Riley says that the final order of removal does not include determination of where you are going to be removed.
Where are you gonna send it? Where would you send it?
I don't have the answer to that.
Well, you're telling us that it had nothing to do with removal, why can't, you can't answer that question, so you don't know, you can't assert.
You say you didn't have an answer to that?
I don't I assume you're asking me where he would be sent if not to El
I thought that
Salvador?
was a direct question, you don't have to assume it, yeah, that's what I asked you.
I don't know the answer to that question, Your Honor.
Well, El Salvador is where the MS-13 is, right?
That's where he's asserting,
Yeah,
Claim,
and that's
yes.
where he was raped.
yes, Your Honor.
He was found credible,
Yes, Your Honor.
so we accept what he said, he found credible.
No, Your Honor, under Ming Dai
No,
v. Garland.
We don't find him credible.
I'm sorry?
He's not credible, are you saying that?
No, Your Honor.
We don't accept that.
Your Honor, what I'm saying, your question was what to do with the credibility finding? I'm
So
merely,
there's a credibility finding in his favor.
yes, Your Honor. And we're not disputing that here. Okay.
I'm wondering here about the jurisdictional question to one side. If you accept the petitioner's view of the matter, it would require Congress to actually state in the statute that equitable tolling is not allowed. And there's no statute that I know of in the entire code that says that. And so you would have to force Congress to rewrite a large body of law, because that's not the way the law is written here. The law is written that you have a rebuttable presumption, that there may be a presumption in favor of equitable tolling, but it's also rebuttable, and the rebuttal is simply the language of Rule 26, which requires a specific authorization in law that isn't present in this statute. And if you say, well, that's not enough to rebut the presumption, that clear language and that clear rule is not enough to rebut the presumption, you're pushing Congress in the direction of saying you have to use the words no equitable tolling is allowed in the statute, and there's no statute written that way.
Your Honor, I am not aware of any such statute either, and in fact, Congress would have enacted all these
But
statutes.
isn't that where all this is leading, if this is insufficient?
That if Rule 26 B2 is not sufficiently clear that equitable tolling does not apply here, then I suppose it could be the case that Congress would have to do a lot of redrafting.
But then Congress would have to rewrite a vast body of federal law.
That may well be the case, Your Honor.
If this is insufficient, this language that says it must be filed within 30 days, plus a rule that says equitable tolling is not permitted unless you have a specific authorization in law. That's about as strong as a case can get. And if that's not insufficient, then the only option left to Congress is to rewrite a vast body of federal statutes. And none of them are written that way, and because Congress entrusted the courts to take the specific directive in the statute and the specific directive in the rule to clearly convey its intent.
Yes, Your Honor. In fact, something else that The petitioner is asking this court to read into the rule itself the equitable tolling presumption. He's not asking.
Asking the court what?
He's asking this court to read into the rule, not into the statute, but into the rule itself, an equitable tolling presumption. But Rule 26 is, the cases that he cited for this proposition that, for example, motion to reconsider, motion to reopen, those are purely creatures of statute. They do not deal with proceedings governed by the Federal Rules of Appellate Procedure, which govern this court. This court is governed by FRAP 26B2.
There has to be a specific authorization in law. It's, the word specific authorization in law in order to extend these time deadlines that are expressed as must, et cetera. We know what the time deadline is. We know there's not a specific authorization in law to extend it. And as much as we might wish it were otherwise, at some point we just have to follow what the rule and the statute, what they said. We just can't blow past it. It just is not open to us as judges to take the words specifically authorized by law, note that they are absent, and then say, well, none of it matters.
Yes, Your Honor, that is correct.
Well, what did the Supreme Court do? That's where we take our orders from the Supreme Court. When they had Riley, did they say that there was nothing, there was no equitable toll, there wasn't available?
They left the question open, Your Honor.
They left it open. Well, they're better than us, and Rule 26 and all that was carte blanche, period. In the story, they could have said that.
It was also not raised, it was not an issue, I think,
It's not an issue. That wasn't an issue as to whether or not, in fact, he had challenged timely
trying to remember.
Removal order.
Okay, no, that's right.
Okay,
If
it
it were
is
not
right,
jurisdictional, if it were not jurisdictional, it was, I believe, was it that, I think it was that case, and also Martinez.
I don't think you know Riley, do you?
Where the government waived the timeliness issue if it were not jurisdictional. I believe that's the case. So that the court did not actually need to reach whether equitable tolling applied in its particular context.
I'm not arguing, and I'm not talking about jurisdiction.
Yes, Your Honor.
I want to make clear, I am talking about the plain language of the federal rules and the plain language of the statute. And the fact that is, they're just time after time after time, I don't agree with something. But as a judge, I've got to follow the text and I've got to follow the rule. And that's just basic. It's a primer. And, here, and again with this NutriCal or whatever decision, as bad as it might seem, Congress is tightening up on delays. And the statutes are becoming, and the statutory limitations period are narrowing. And that we may not like that development, and we may not like that trend. But the Supreme Court has said, do not just allow these delays to go on in hopes that sometime in the future there will be a favorable decision comes up and we can latch on to it. That is just not the way the Supreme Court is ruling, and it isn't the way that Congress is ruling. And it may be personally distasteful to me, but the law is the law.
Yes, Your Honor. The federal rule is what applies here. There's no exception built into the rule. There's no specific exception built into the statute. And that ends the inquiry on
So your
tolling.
position is never any equitable tolling?
For a petition for review of an agency order in this court, correct.
So you say, but you're saying there's no jurisdiction. You got a motion to dismiss here.
So the motion to dismiss was before Riley said it was not jurisdiction. The timeline,
You say no jurisdiction. You say there's no equitable tolling.
There is no equitable tolling. We do have a jurisdictional argument, which
But
is
you
that,
say that there's no jurisdiction. That's your first point.
yes, Your Honor. No
Are you
jurisdiction,
giving that up?
no, Your Honor.
Okay.
I-
Now, what'd the Sixth Circuit do to you?
The Sixth Circuit, they held there was equitable tolling, and they got the question wrong.
That was just, what, a couple weeks ago?
Very shortly, I don't
I
remember.
mean,
the
you
exact-
wrote us a 28J letter. You know what that is?
Yes, sir.
Or somebody did.
Yes, I
The
did, Your
Justice
Honor.
Department wrote 28J letters about the Sixth Circuit case.
Yes, Your Honor.
And they held there was equitable tolling.
They did, Your
So you
Honor.
got one of the circuits, how many circuits have said there are equitable? There is equitable tolling,
I believe the Sixth is the first to weigh in on this specific question.
the Sixth.
Yes.
So and there was a motion to dismiss there, just like this. And they denied it and said there was equitable tolling.
I believe that's correct. A motion to
Yeah.
dismiss or for summary
You
disposition.
believe
of some
that's
sort.
correct? You don't know then, or do you?
I don't recall immediately whether it was a motion to dismiss or a motion for summary disposition.
So you want us to have a circuit split then? You urge us to have a split on it?
Yes, Your Honor,
So
because
if
this,
we go, you're arguing then for a circuit split.
yes, Your Honor.
That you're saying we should go against the Sixth Circuit.
Yes, Your Honor.
Okay.
You're not arguing for a circuit split, really. What you're arguing for is an application of clear statutory language and clear textual guidance from the rule.
That is correct, Your Honor. That's
But
what we
that
are arguing.
results in, you have to be arguing for a circuit split because you just stood there and told us that the Sixth Circuit ruled against you and in favor of equitable tolling.
I apologize, Your Honor. I meant to say I agree with that we are arguing for a clear
I
application.
know that's what you're arguing for, but the Sixth Circuit ruled against you.
Yes, Your Honor.
So if we rule against the Sixth Circuit, we're creating a circuit split.
And I agree with that, Your Honor.
And you agree with that we are. Okay.
Yes, that's what we're arguing for. We're
You're
arguing,
arguing for a circuit split.
yes, Your Honor.
Are there any other circuits who have weighed in directly?
The First Circuit has held that not in the the First Circuit has specifically said that this rule prevents the petition for review's timeline from being extended. That was in Gonsalves v. Bondi.
So the Sixth Circuit agrees with you?
No, the First Circuit agrees with us.
Who?
The First Circuit,
The First Circuit agrees with you.
yes.
That's what that's what I intended to ask. I didn't, it wasn't very clear.
Would you say why you think the First Circuit agrees with us?
The
So
First
there's
Circuit,
already a circuit split.
I guess the Sixth Circuit created the circuit split in that sense, yes.
So the Sixth Circuit's going one way against you, and the First Circuit's going your way.
Yes, Your Honor.
So we're in position to take one side or the other.
Yes, Your Honor, and I would like to clarify that the First Circuit looked only at the rule, not at the statute, at the 1252, whether there was equitable tolling, whether the statute affected anything. They looked only at the rule and said the rule did not allow for extensions.
They were position not our position, but some of the queries that Judge Wilkinson was saying about the rule. Right, that's what they looked at.
They only looked at the rule because that was, the equitable tolling question was not before them in
Right.
that case.
That wasn't before them.
I'm sorry?
It wasn't before them, right. But the circuit that was before them, the Sixth Circuit, ruled against you.
That is correct, Your Honor.
So on that point, we would be a circuit split.
Yes, Your Honor.
Okay, right.
And the reason this court should disagree with the Sixth Circuit is that they disregarded the express instruction of the Rule 26B2. They looked at it instead of as the rule that governs how you interpret statutes. They interpreted it the same as a statute. They imported the same presumption from Irwin that you give to statutes to the rule.
Did you argue the case in the Sixth Circuit?
No, Your Honor.
Did you argue the one in the First Circuit?
Yes, Your Honor.
So you're on you're the winner. One of your people in the Justice Department went out there to Cincinnati and lost.
It was not argued. It was decided
Well, it
only on the
wasn't
briefs.
argued. Well, it went to Cincinnati and lost.
Yes, Your Honor.
It was-
I did, to me, and you know, you must forgive me, but I see this in rather simple terms. And I see the language that, and I apologize for hammering the point, but I hammer it only because it seems to me so clear, that it says that you should not extend the statutory deadlines unless specifically authorized by law. And the word specific, authorized by law, means that Congress would have to take some sort of positive step under law to allow the extension to take place. And not only is there no positive step of any sort, but there is a, to the contrary, the statute that we're dealing with and the statutory limitations period that we're dealing with says the petition must be filed within 30 days. That's not only an absence, that's not only an absence of any specific authorization by law, it's the exact opposite. It's that to the extent you look at that language, it disallows. It uses it must be filed. It disallows a specific authorization in the context of where the federal rules say there has to be a specific authorization. And it's absent. There's no specific authorization here. And even beyond that, it's the statutory directive is expressed in clear, emphatic, directive language.
Yes, Your Honor, that is, in fact.
That's where it bottoms out, and it's not that complicated. And we've been told here we can imply this and we can imply that. But when I hear the word specific authorization by law, that seems to me to cut off implying things. It's a direction to the court, don't go around implying this and that, and it's read the statute. See if there's some specific authorization under law.
What's the word equity mean to you?
Equity means, I guess, fairness.
Fairness, yeah. But isn't equity the whole, without getting to the deep thing about legal theory, but isn't in fact, equity was created because it fills the gap where law is not adequate. That's the whole idea of it. Where law is not adequate, it's an equitable type thing.
Historically, that is how it was created in our current jurisprudence, where a law is speaking clearly, equity does not intercede.
Equity doesn't, there's no view of equity that I've heard of that allows you to disregard a plain statutory text. If that view of equity is undertaken, we might as well be lawmakers from the bench. Why rely on Congress? We have our own. View of what the law should be. Congress says must be filed within 30 days. Well, we have a different view, so we'll amend the statute. But the point is, with all respect to opposing counsel, equity does not allow a court to disregard plain statutory directives and plain statutory text. And if it did, we're off into, I think, some wide open field. And the implications of it are multiple and unsettling.
Your Honor, the government agrees with your position, and unless this court has any further questions, the Attorney General requests you deny or dismiss the petition for review. Thank you.
right, Mr. Porter, please.
Thank you, Your Honors. Just a few points that I'd like to clear up. I'll start with equitable tolling. The government argues that we are asking you to read the equitable tolling into the rule of the rule of appellate procedure. That is not what we are asking you to do today. The equitable tolling principle goes directly into the statute. Congress knows when passing laws that equitable principles will be infused into them to account for extraordinary circumstances where petitioners exercise reasonable diligence. Congress did not intend, by approving the appellate rules of procedure, which are not a statute and not drafted by Congress, to foreclose the
Well, the federal rules bear the imprimatur of Congress as well.
They do, Your Honor, yes.
I mean, you say Congress is not, Congress's view is expressed in statutes, to be sure, but Congress's view is also reflected in the federal rules. That has to go through a process, I think the final step of which is that Congress must sign off on it. Congress has to sign off on it. And it's not something where they're just invariably rubber stamping things in Congress. There are a lot of these rules, there are a number of these rule changes that generate quite a bit of controversy. And so I don't think that we are permitted to assign to the federal rules some sort of lesser status. If we are, then all bets are off.
Well,
If
Your
that's
Honor,
the case, then wouldn't it be superfluous to even talk about whether the rule is jurisdictional or not when it was at the Supreme Court, right? Was it? Wouldn't it be, why would you talk about jurisdiction if Rule 26 said you can't change it whether jurisdiction or not?
I'm sorry, Your Honor.
I mean, otherwise, my point is, why do you have to even, why would you have to even talk about jurisdiction if position you could be taken that, well, you can't change it anyway because there's nothing that allows equitable tolling?
Right, yes, Your Honor, and the government concedes that Congress would have to rewrite every single statute to expressly account for equitable tolling, if so, which would, create a whole host of problems. I'd also like to talk about the fact that we are challenging the removal order by challenging a term of it, namely where Mr. Navarro will be removed to.
I suppose the hardline view on this case would be that there's no jurisdiction and then cuts off everything, but I'm not going that far. I'm not willing to take the step that says there's no jurisdiction. Congress controls the jurisdiction of the federal courts, and if Congress wants to make its position clearer than it presently is, Congress can do that because Congress controls federal court jurisdiction. But I'm not going that far. I'm not arguing for an absence of jurisdiction.
Understood, Your Honor.
And
We
by
agree.
not going that far, it leaves it up to Congress to change it at any time simply by changing the language of the rule or the language of the statute. Either one would suffice. But what doesn't suffice is the combination. That's where I stumble. Although if either prong, if the statute was changed or the rule was changed, we got a whole new ballgame. And I'm not going from, I'm not saying that this is jurisdictionally prohibited from us to asking the question of equitable tolling. I think we get that, but I think the answer presently is clear from the rule, the combination of the rule and the statute. But that doesn't mean that that's frozen. It can change. Any one of those could change. And by saying that I think there's jurisdiction, it leaves it open. It leaves it open to change on either prong.
Yes, Your Honor, and I see my time has expired.
Do you agree with the status of the circuit split that counsel for the government explained?
Mostly, Your Honor. I mean, the Sixth Circuit has gone against the government's interpretation of whether equitable tolling should apply and if nutraceutical factors in at all. The First Circuit case that they mentioned was only about the federal rule of appellate procedure and whether it cuts off review, not at all examining whether equitable tolling was present. So there's not an existing circuit split. The government is asking you to.
So
create
there's no circuit split on equitable tolling.
one. Correct.
Right.
There you go.
Well, I'm not in favor of circuit splits, but if there were never such a thing as a circuit split, then the first court out of the gate would decide the issue for the entire country. And the rest of us might as well just hang up our cleats, take them to the locker room, because we're in a position, we're taking the position that once one circuit comments on something, it's all but foreclosed from another circuit even expressing a different view. And I don't think the judicial system was set up in such a way that one circuit determines for all.
Yes, Your Honor, and I would certainly not encourage you to hang up your cleats.
It certainly doesn't, but I guess Supreme Court will have to eventually do this. So the question is, where does the Fourth Circuit want to hang its hat? On the rail that talks about equity in terms of cases like this, with just brutal type facts, and then it doesn't apply, or on another side of it. So you're right. If first come, first rules is not the rule, but at least when you get a chance to look at it, which side do we want to hang our hat on when the Supreme Court decides this case?
Yes, Your Honor.
But
And
your
we-
point is there's not a circuit split yet.
Yeah.
Correct.
Right.
We got that straightened out.
Yes, yeah,
Not a
correct,
circuit split yet,
correct. And yes, we think
because equitable tolling hasn't been dealt with.
yes.
Right.
We think the reasoning in Oxlade-Perez in the Sixth Circuit is very persuasive. And again, we respectfully request, Mr. Navarro would have had to foresee the future in terms of the law changing drastically in his case in order to secure review over the BIA and the IJ's numerous errors, legal errors. And that is not simply what equity in the law demands. So we respectfully request that you remand with instructions to consider all the evidence fully. Thank you.
We thank you. We'll come down and greet counsel. Bob, do you want to go into the next case, or would you like to take a break?
I need a break.
All right. We'll take a brief recess and then come back and hear our final case.
Could say I desperately need a break.
Well,
Council, the judges of the United States Court of Appeals for the Fourth Circuit.
Kindly be seated. All right. Ms. Templin?
Good morning, Your Honors, and may it please the Court. Hannah Templin for Appellant Felicia Morgan. When the District Court granted the officers summary judgment and qualified immunity, it ignored key factual disputes that cut in plaintiff's favor. First, the Court ignored that Officer Gonzalez was on the scene for more than a half hour before he pulled the trigger, but failed to warn Bobby at any point. Second, the Court ignored that both Officers Gonzalez and Rude could see when officers' bullets impacted the window, and that Bobby's gun caused no similar damage. And third, the District Court resolved key credibility disputes against plaintiff. For example, crediting Officer Rude's testimony that Bobby was using his fake gun to threaten officers over Bobby's contrary testimony that he did not. These errors flunked both the reasonableness inquiry in Barnes and the summary judgment standard. The Court should reverse on excessive force, or at minimum, vacate and remand for the District Court to redo its work. The Court should also reverse on the ADA. The District Court concluded that Charlotte had no duty to accommodate Bobby's mental illnesses because circumstances were, in its words, exigent from the start. But the record belies that conclusion. At minimum, the city could have taken openings to warn Bobby to stand down or used a mental health officer already on the scene. I welcome the Court's questions. I'll start by discussing the Court's grant of summary judgment and qualified immunity. Qualified immunity is improper when a right is clearly established. And cases like Cooper and Hensley clearly establish that when an individual is standing on his own property holding a gun, officers cannot use deadly force unless they both reasonably believe that he poses a threat and, where feasible, warn him. Viewing the record in the light most favorable to plaintiff, as is required at this stage, there are reasons to think for all three officers flunk summary judgment and that standard. I'll start with Officer Rude. Officer Rude fired a gun at Bobby for only one reason, he says, because he believes he saw, or he says that he saw Bobby tracking Officer Gonzalez with his gun, aiming it at him. But Bobby says differently. He says he never pointed a gun at officers. And for that matter, Officer Gonzalez, who was also looking at the same window, also says that he never saw Bobby point his gun at him. That dispute has to be resolved in Bobby's favor at this stage. And that makes the case look exactly like Cooper and Hensley. If Bobby is simply standing in his window holding a gun and not pointing it at an officer, Officer Rude could not pull the trigger. To top it all off, there are reasons to believe that Officer Rude knew that Bobby's gun was fake. When he arrived on the scene, he talked to Officer Gonzalez. He knew that
What
Bobby...
do you mean by the gun was fake?
The gun was only firing blanks and not firing...
It fired blanks, but it was a 9mm Magnum.
But because it was
A
firing...
9mm Magnum.
The gun...
It was a legitimate gun that had been modified in the barrel some way or another that wouldn't let a projectile through. But it was a 9mm Magnum. Is that right?
The gun looked real, yes, Your Honor.
It looked absolutely real. It had been real before, I guess, before somebody obstructed it.
Yes, Your Honor. However, there's no dispute.
And this young man was mentally impaired.
Yes, Your Honor. However, there's
How
no...
does he get a right to possess a weapon like this?
The weapon was not real and could not fire bullets.
Well, it held 15 rounds of ammunition that would go off.
The weapon, as he possessed it, could not fire
And he carried it
ammunition.
around under his arm in a holster, correct?
He did carry it on under his arm, and that...
In a holster under his, I think his right arm.
He did, Your Honor.
And he claimed to be a police officer,
Yes, Your Honor.
and he threatened two women who were neighbors of his.
Yes, Your
He's gonna
Honor.
blow their heads off
This
with
is,
a expletive
yes,
Is that correct?
that is correct, Your Honor. That is not
And is
some-
that not a prohibited weapon under the firearm laws?
because it could not fire projectiles.
Well, a frame is prohibited, a frame of a firearm.
Well, there's no
It's
dispute.
under the very same statute,
Well,
under
he,
section B.
I don't
If you
believe
look
he
at it,
was-
possess,
I don't believe he's ever been charged with.
and that's a felony for somebody's mentally impaired to possess a firearm. Now, you can argue that this wasn't really a firearm, but you haven't got a very good argument.
Well,
But I don't know which side that even's on here in this case. What's because the police officer saw that.
yes, Your
They
Honor.
knew he carried a firearm. He carried this, I think you all, somebody even called it a toy gun.
Yes, Your Honor.
But it was a 9mm Magnum
Your Honor,
that
the,
was fitted for
And it sounded
15
like,
rounds.
it sounded like real shots.
it did, however, bullets were not
It sounded
impacting.
like somebody was an active shooter.
Yes, Your Honor, but however, both officers Gonzalez and Rude on excessive
Well,
force.
what would you expect a police officer to do? To wait until somebody that's firing in the vicinity and is the officer supposed to wait until somebody actively trains his gun on them before they can take action? Because by then it's gonna be too late. I mean, these folks are, what's he supposed to do, negotiate with an active shooter? He'll get his head blown off.
A couple responses, Judge Wilkinson. First, yes, cases like Cooper and Hensley indicate that both you should warn.
Well, why should he have to wait until somebody has him in a direct line of fire? He's certainly shooting all around in the vicinity.
In Officer Gonzalez's case, the problem is that he noticed that officers' bullets were impacting the window, but not that Bobby's were. But going briefly to some of Judge
So
King.
the blanks were working, the fact that the firearm was obstructed, the 9mm Magnum, the barrel was obstructed somewhere or another, presumably modified, I guess. I wouldn't think it'd manufacture something like that. And I wonder why he wasn't arrested on the spot before any of this happened.
And that goes to on Felicia's ADA claim. Officers Tilson and Ellis.
I don't know who that helps here, but that might not help you.
When Officers Tilson and Ellis arrived on the scene, they knew he was carrying a gun or something that he said was a gun. He had told 911 operator that he had something that he said was a gun.
Yes, but the bottom line here is that the plaintiff here would require, would, even when an officer's life, very life is in danger, he's still not allowed to take preventive action, even when his life could be on the line.
Respectfully, Your Honor, we disagree for a couple reasons. First, with Officer Gonzalez and Rude, the key point that we assert is that they knew their lives, or they should have known their lives were not in danger because there were no bullets impacting the window.
Do you agree with me that they could have arrested him on the spot when they saw the firearm?
We have maintained since the district court that Officers Tilson and Ellis could have arrested him, they could have frisked him and taken the gun away, and the fact that they did not do so and they did not provide mental health support, and then they never once, both earlier in the encounter and then through the 30 minutes when all he was doing was popping behind a window and showing CDs and money, and his wallet never warned him to drop the gun, mean that the city and the officers violated the ADA in those circumstances. And moreover, the fact that Officer Gonzalez was on the scene.
But we have to deal here with the situation that the officers actually confronted. And they heard these shots go off. They sounded like shots. Actually, they were blanks. He was shooting very much in the vicinity, and you just don't, I don't think that our decisions, our Benton and Layton decisions, indicate that the police need to wait for a suspect to take aim before they can respond with deadly force. In other words, if they had to wait for the suspect to take aim at them before they could respond, we're going to have a great many more deceased police officers. It's that clear. And whether the weapon was actually aimed at Mr. Gonzalez, that may be in dispute, but the officer was absolutely within the gunman's line of vision. There's no dispute that this gun could have gone off, could have reached, the bullet could have reached the officer. It could have inflicted fatal force, and the officer was plainly within the plaintiff's line of vision here.
Your Honor, especially with cases like Cooper and Hensley, the same was true there. An individual was carrying a gun, saw officers, and encountered them. However, in those cases, because the individual was not pointing the gun at officers, and officers, especially in Hensley, had not taken the opportunity to warn, the court found that qualified immunity was improper. And especially for Officer Rude, who did not, Bobby at this point was not firing the gun through the window. He was simply standing in the window, and there's a just clear disputed fact whether he was aiming the gun at officers or simply standing there holding the fake gun. And if he was
but Officer Gonzalez, for example, he was hearing gunfire. He was learning over the radio that the gunman had been discharging his gun, aiming it at officers, aiming the gun at officers, and refusing police commands. And then seconds later, he sees the gunman shooting out of his front window. Now, this is, I don't understand when people act reasonably to protect their own lives and those of their colleagues, that they should be hauled up in a 1983 suit. I don't understand that. If you hear gunfire, if you heard over the radio that he was discharging the gun, that he was actually aiming the gun at officers, that he was actually shooting out of the front window, that he was refusing police commands, what more do you need?
Judge Wilkinson, on the point of whether he was aiming previously at officers, we'll just note that this too is a disputed fact. Officer Skipper testifies that he believed Bobby was aiming the gun at him, but again, Bobby disagrees with that and says he never aimed the gun at Officer Skipper or any other officer, and body cam footage does not resolve that dispute. So at least as to Officer Skipper, on that point, there's a disputed fact. But turning back to Officer Gonzalez, regardless of what he was told on the radio and the fact that he saw Bobby firing something that looked like a gun out of the window, he also could see that what he thought was a gun was not firing real bullets impacting the window. And we expect officers to use common sense and to note things around them. Again, in cases like Cooper and Hensley, expect officers to be able to tell when somebody is threatening them with a firearm as opposed to simply holding the firearm. This is what the reasonableness standard is about. And if Officer Gonzalez could see that there were no bullets coming from the gun, his belief that Bobby was posing a threat was unreasonable. The same is true for Officer Rude, both because there's a disputed fact that whether Bobby was pointing a gun at anyone in the first place, as well as the fact that he had discussed with Officer Gonzalez that Bobby had supposedly fired out of the
Who
window.
bought this gun? His mother, actually, or client?
She,
How did he end up with this gun strapped on himself?
so this is a problem.
And being mentally defective. Everybody agrees he's mentally defective, and that's prohibited by the Title 18.
She does not know. She said at deposition, this is a prop gun that presumably he ordered from online, the type of thing that would be used in movies. I believe originally would have come with an orange cap on it that fell off or was removed at some point. But she, at deposition, knows that he does not have a gun and asks him, a real gun, and asks him repeatedly whether he has one.
And he had threatened the two neighbor ladies. What did he tell them?
He was getting in altercations with the neighbors and had on previous occasions. He called the police to resolve that, and
What did he tell them?
he told them that he wanted to blow their heads off.
With what kind of a word stuck in there?
A word that I'm not going to repeat.
You're not going to repeat the word in the courtroom. You don't want to.
I don't, Your Honor.
But he told him that, and he had a gun strapped under his arm when he told him that.
And at that point,
Isn't that correct?
he did, and officers
How
told
does that apply here, though? That maybe brings in this new Supreme Court case that says you gotta look at all the circumstances. And that was several minutes before this, I guess, before the incident occurred. And the Supreme Court changed the rules, or emphasized the real rule, since this case was decided by Judge Bell.
Your Honor,
And that's what they argue, that ought to be, or somebody argues it ought to be remanded, to give Judge Bell a shot at new case.
Your Honor, my time has expired. May I answer the question briefly?
That's up to Judge Wilkinson.
Do you have anything further you want?
If I ask you a question, I think Judge Wilkinson will let you answer it. If what I said was a question. If you consider it a question, I'm sure Judge Wilkinson will let you answer.
To very briefly answer, the initial interaction was not something known to Officers Gonzalez or Rude when they arrived on the scene. However, it does factor into the ADA determination of whether Officers Tilson and Ellis and the rest of the police department were accommodating Bobby's mental illnesses from the start.
All right, thank you.
Thank you.
Judge Gregory, do you have anything? All right. Mr. Bader?
Good morning, and may it please the court. Stephen Bader here for the three officers, Skipper, Gonzalez, and Rude. My colleague, Taylor Imperiali, is here for the city of Charlotte to address the ADA claim. This court should affirm summary judgment for the officers on either one of two grounds. First, on the constitutional ground, because a reasonable officer on scene would have perceived Bobby to present a lethal threat given the totality of the circumstances. Specific as to Officer Skipper, he also has an additional argument that he never, in fact, seized Bobby, which would provide a separate basis to affirm summary judgment on that ground. And second, as to all the officers, this court could affirm on the qualified immunity basis because Bobby did not have a clearly established right to be free from lethal force under the totality of the circumstances present here. What this court has, what the Supreme Court has instructed in considering the constitutional prong is the 3 Graham factors. The severity of the crime, the risk that the suspect presents to officers as well as to others, and then whether the suspect is evading police. All 3 of those factors are present in this case. What the record here shows is that after the initial encounter with Officers Tilson and Ellis, and after Bobby's making threats to his neighbors, he goes inside of his home where he fires a gun. And the body-worn camera shows that Officers Tilson and Ellis, hearing that gunshot, believing that's a gunshot, take immediate action to try to secure this area. They move the neighbors away from the property. They clear the street in front of the home so that passerbys are not at risk. Within about 13 minutes of that shot, again on the body-worn camera, Bobby shoots again. And I should back up and say before that there's also a call for backup. So as to Officer Skipper, he takes position behind Bobby's home. He's hearing these gunshots, and he hears that this is a call for service with an active shooter. He sees Bobby come outside of his house and shoot the gun. And at that point, Officer Skipper announces himself and says 3 times, "Drop the gun, drop the gun, drop the gun." And Bobby doesn't do that. Instead, he retreats back into his house, and of course, before that, Officer Skipper does try to shoot Bobby and does not hit him. Bobby goes back into the home, goes to the front of the window, which is where Officer Gonzalez can see from his position behind a tree. Officer Gonzalez is hearing radio traffic that there's been shots fired. He hears that there's been warnings given, instructions to drop the weapon, and that the suspect is not compliant. About 90 seconds between when there's the interaction with Officer Skipper, Officer Gonzalez sees Bobby in his window, and he sees him fire his gun. And about 5 seconds after that, Officer Gonzalez fires his single shot.
But they say the window didn't break. So they knew it was blanks?
Your Honor, the fact that window didn't break is one factor among many in the totality of the circumstances.
So all the totality of the circumstances applies.
Absolutely, and that is the accounting that the district court did. When you look at Joint Appendix 1668,
Did the district court take into account the fact that he had threatened these neighbors and was carrying that 9mm cannon under his arm and it was loaded?
I believe so, Judge King. I believe when you start at page 16.
Why didn't they arrest him on the spot?
Well,
For having that. He's mentally impaired. Everybody knew he was mentally impaired. His mother was apparently giving him that gun to placate him, to let him go around and act like a police officer. He showed one of the police officers his ID, or showed somebody his ID.
Right.
Correct?
that's correct. I just,
Yeah.
with some of
As a
your,
police officer.
with some of
He
your,
was a police officer, carrying a 9mm under his arm,
well,
and he's mentally defective, and nobody arrested him. And that's against the law, is it not?
well, I don't want to get too far afield other than to say that
Well,
implicates
you're not getting
things.
far afield, that's
Well-
part of the facts
well-
leading up to the whole thing.
But as to
They
the,
didn't arrest him and he ended up in a shooting incident.
as to the
And
three,
he threatened those women at the time, and the police officers knew that.
well, as to the 3 officers that I represent, Judge King, their information
And
is,
that doesn't mean that maybe they are entitled to immunity. I don't know how that helps, but those are facts that I think relate to the totality of the circumstances.
well, they relate to the
They
totality.
lead up to the circumstances. That's
Absolutely.
the totality of the circumstances.
Absolutely, and I believe that the district court does that accounting
That
starting
the
at
shooter
page.
is mentally impaired.
That's-
The one that they deemed the shooter was mentally impaired. He was firing blanks, and that somebody had gotten him a 9mm cannon to put under his arm and walk around as a police officer and threaten his neighbors.
And the totality of those circumstances would justify lethal force by the 3 officers that found themselves
Well, it
in this
wouldn't be
situation.
lethal force at the time they knew it. That one of them was standing there with him.
Well,
They knew, one of them, didn't somebody handle the gun and hand it back to him?
right, between Tillis and Ellison, or Ellis and Tilson, I'm sorry, who are not parties to this case. As to these officers, though, those facts are relevant in that they inform the larger picture, which, as you point out, is somebody who apparently is mentally ill, who apparently has access to a weapon, who's apparently made threats to their neighbor, and who, after Officer Tilson is trying to speak with him, chooses to go back inside of his home and then fire off his gun, sparking this response. That is what my clients are hearing on radio traffic, and that's what they know as they come to this scene. And then they are seeing a scene that is deteriorating, starting when Bobby leaves his home.
How many rounds did he fire altogether?
Bobby?
Bobby,
I think 7.
did the post incident investigation confirmed that in the
That-
context of his firearm?
I don't know the answer to that, Judge King. That's
Is
possible.
that
I
not
don't
in
want
the record? I thought
It-
they
it-
investigated.
It may be. What I can tell
How
you
many
is,
rounds went out of that 9mm?
I don't know if that's in the
Or
record.
blanks,
Yeah.
firing blanks. But there were 15 in it,
Right.
at least according to the, it's in one of your briefs.
Right. And that's right.
The picture of it.
Well, right. And I think that's right. My recollection is 7 shots were fired between.
So the totality of the circumstances analysis has never implied that we should not consider the present circumstances with which an officer was confronted. That's part of the total picture. And the present circumstances here, well, the fact that the officers knew that he was firing all shots, had heard the shots, knew that, saw the individual through the window, knew that they were within the line of fire, that officers were within the line of fire, and they actually heard, before they arrived on the scene, they actually heard the shots. This is not something where, most of these excessive force cases, you don't have actual shots being fired. It's just a question of where the police acted precipitously in shooting someone who maybe never drew a gun, or somebody who was fleeing or whatever. But this is a very different case. This is not a situation where somebody is fleeing. It's not a situation where somebody never drew a gun. It's a situation where you actually hear the sound of what appears, they were blanks, but all agree, understand that they were that they were indistinguishable from actual bullets. But I just want to point out that this is really different. And to say that officers can't act to protect themselves in a situation where they have heard actual shots from a scene in which they're about to arrive, that would carry these excessive force cases a real step further, because I don't know a situation where somebody has been heard to fire and shooting and the rest, where it says the police officers are prevented from protecting their own lives. Maybe they should have arrested him and the rest, but that still doesn't get to the question that they were arriving on a scene in which they heard and saw actual shots being fired, or blanks that appeared to be shots. And that's what I'm concerned about here, is that we may be saying, even in a situation where officers heard gunfire and arrived at the scene from which the gunfire was proceeding, even in that situation, they can't act to protect themselves. That's a real big step.
I agree with all those comments, Judge Wilkinson, and just to kind of parry off them a bit, that's where this case is so different from Cooper and Hensley.
Yeah, it's altogether different from what we generally confront, which is a situation where nobody's drawing a weapon, nobody's firing a weapon, people are fleeing the officers, and they shoot first and ask later and everything. Here they have and have heard and are seeing an active shooter in a situation who has the officers well within his line of fire. And we haven't as I know, taken the step of saying that officers are powerless to act in that situation.
Now, the shots he fired, the 7, were just as loud as they would be if they had projectiles, right? Firing
Correct.
blanks is just as loud. Got the same amount of powder.
That's correct, Judge
Yeah.
King, and the district court does make a notation that I also emphasize in the brief where Ms. Morgan's counsel, in fact, mistaken one of Bobby's shots for an officer's shot. But yeah, that's absolutely correct. Let me just conclude with this other remark. I think, unless the court has any other questions on the constitutional prong, I think I've made my arguments and would rest on the briefs. But just as to Officer Skipper, there's a separate issue with him, which deals with the fact that he didn't effectuate a seizure because he didn't actually hit Bobby. There's an argument here that he sort of effectively caused Officers Gonzalez and Officers Rude then to effectuate that seizure. I would just really offer 2 comments. I think first and foremost, the situation that Officer Skipper found himself in justified lethal force on its own. So even if there was a seizure, he would be entitled to qualified immunity. But secondarily, Officer Gonzalez, as well as Officer Rude, they acted independently based on the circumstances in front of them. They did not choose to use lethal force because of what Officer Skipper did. So I think to suggest that doctrine should be expanded on these facts simply would not be supported. And I think, again, we've covered the constitutional prong ground, but I would just add in conclusion that if the court, for whatever reason...
Anyone who acts in the same way that Bobby acts, anyone who engages in this behavior probably is mentally defective in a way. And so we can sort of roll back the time and say, well, this person was mentally defective, and I would think, but that's still, if we were to go down the road of saying, well, you should have arrested this person or you shouldn't have arrested that person and the rest, it doesn't address the present circumstances with which these officers were confronted, and asking whether such and such individual should have been arrested and shouldn't, or this person shouldn't have been arrested. I understand that, but on the other hand, I don't know whether these officers were responsible for not arresting somebody, or who could they have gotten close enough to arrest somebody, or could they have arrested them beforehand? That's a whole can of worms. It's a large can of worms, and it doesn't address the question that these officers were in present danger. That's the thing, and I think that you can look at the totality of the circumstances, but there are situations where asking whether a prior arrest would or would not have been justified and everything, I just think that's a can of worms. But what's not a can of worms is the fact that these officers' lives could have been taken very easily, very, very easily. What's not in dispute is that he was told to drop his gun 3 times, and he didn't. 3 times he didn't. And he continued firing. And what is a police officer supposed to think? What are they supposed to think?
Yes, and the body-worn camera certainly paints that picture. I thank the panel for the argument this morning. I would ask this court to affirm summary judgment for the 3 individual officers. Thank you.
Mr. Imperial.
Taylor Imperiale for Appellee City of Charlotte. May it please the court. I'm speaking separately on the ADA claim against the City of Charlotte. The district court was correct in granting summary judgment for the city on plaintiff's ADA claim. This court does not require that officers provide additional accommodations once a suspect presents with an objectively deadly threat. To use the words of this court in the Waller case, plaintiff's ADA claim asks this court to lean far in the direction of impermissible hindsight to say that Mr. Morgan's injuries flowed from the city's not providing certain additional proposed and frankly novel accommodations that were unreasonable given the exigent circumstances with which the officers were presented.
Why was that novel? Why you say it's novel? But it was broadcast that he had history of mental illness.
Yes, Your Honor. I'm not saying that.
Is that right?
Yes.
Matter of fact, an officer arrived there who had some training there and then decided that he was going to do it himself rather than call an expert. So this is not the exigency it's quite as much as you're talking about. You know, you got to start the film from the beginning, not at the end. Right? Am I wrong, that an officer made decisions? Well, no, I know him personally. I know about his history of mental unwellness, and I can talk to him, right? Is that right?
Yes, Your Honor.
So and at some point, did he drop the gun and they gave it back to him?
He dropped the gun, it fell out of his pocket, and Bobby picked it up himself. The officers didn't.
But they let him do that.
Yes, Your Honor.
He put it back in the holster,
Yes.
which was under his arm on the right-hand side.
And they knew he had mental illness and was not only had a history, but he was in episode. He was, right, at the time. They knew that.
Your Honor, so 2 points. I would.
Threatening, right? Because he had a problem with the neighbor and he thought they were disturbing him. So they know he was in a manic form. And he drops the gun and they let him have it back?
First, Your Honor,
am I wrong yet? I'll get the facts before you give your...
You're not wrong about anything you
Okay,
said.
go ahead. Now, tell me now about this exercise. We're right here now.
Yeah. So on the point of what the novel accommodation that's been requested is that appellant suggests that an accommodation would have been to seize Mr. Morgan. And whether they could have lawfully done that is not really a question before the court. What is a question before the court is whether not having seized him constitutes a failure to accommodate him under the Americans with Disabilities Act.
To me, that's a strong linkage right there. You have a history of it. He's in manic form right now. You know that personally. It's not like, well, this is a random person. That's a record. Your own client, right? The police officer know that. And you let him pick up the gun, holster it, and then let him go back into the house. And you say there's no linkage between that and what eventually happened. It wound up to be a shooting. How could that be?
What I'm saying is
just
that
logic now. I mean, you're a lawyer. I know you're a very smart lawyer. How could there not be any linkage between those things that happened right there and what ultimately happened? How is that not a linkage? Tell me that.
I agree that if the officers had arrested him in the moment, things that happened after might not have occurred. But that's not to say, though, that's an accommodation required by.
That was not a split-second decision, though. That's different. You can't allow something to go on and then to the point where, as Judge Wilkinson told me, you have officers there facing, I don't know whether it's a real gun or not, and shooting. But the point is, on the ADA claim, the whole idea is that you had an opportunity of knowledge, allowing him, not you, but your clients, and the city, the alleged respondent, because we're right here, that's a factual question. That's a factual question whether or not that, because I can see a clear logical connection. Now, whether that fact may be, whether that's may be to determine, but how can you say that you don't have a responsibility? We're not talking about to give him therapy on the scene. We're not talking about psychoanalyzing him on the scene. We're talking about removing a clear and present threat given his present manic condition they knew about. And that led to him going back in, wavering a weapon, who they didn't see any glass break, but forget about that. Even without that, another officer may not I can understand in the pressure of time, you might say, well, I don't know who's glass breaker now. All I know, I hear the weapon being fired, something being fired, I shoot. But that's what the crux of the ADA claim is against the city. Now, you tell me why that's not a factual question in that sense that you do have a responsibility, you agree, don't you, to do some things to help people that you know that are mentally ill?
Yes, Your Honor.
Right?
However, under the Waller case, the court does take into account the exigency of the circumstance in determining what a reasonable accommodation is
But this
under the
wasn't
circumstance.
exigency. Not in that sense. It was not an exigency because he said, I can take care of this. And eschewed getting someone who had the expertise because I can handle it. And handling it, part of it, on the facts, you know, that's to be determined when maybe, another time, but in the Fourth Circuit, we summary judgment, those kind of things, even qualified immunity, facts, we consider that to be jurisdictional when it's still to be determined. Now, you might argue that that's exigency, but on this record, I'm not sure you can say that's exigency when, right? And you haven't disputed anything I just told you in terms of the facts, but you disagree in terms of the ruling. So you don't think they have any responsibility?
Your Honor, I see I'm out of time, but if I may respond.
If Judge Wilkinson will allow you to answer, it's fine with me, but.
Sure. As I've
But I haven't answered in a minute. Go ahead.
I would say, first of all, the city did accommodate Mr. Morgan by having Officer Tilson, with whom he was familiar, come to the scene, and he had specialized training in dealing with folks with mental illness. Secondly, again, there is no authority for the proposition that a seizure is in and of itself an accommodation under the ADA. And finally, on the question of whether there's a factual question, both Waller and Saramith, precedents of this court, determined as a matter of law what was a reasonable accommodation in a given circumstance. And the court should do the same here.
As I understand it, I think there's some limit to the degree that we can afford, that we can require police officers to become psychiatrists. But in addition, the material facts here, I don't think, were in dispute. There may be some argument about his mental disease and what, but there are always going to be arguments if we open this door, because there are always going to be questions about how somebody could embark upon this course of conduct if they weren't mentally defective. But the material facts here are not in dispute. The fact that he disregarded the officer's command to drop the gun, the fact that the officers heard the fire, the fact that the officers were in the line of defendant's fire, the fact that his firearm, as Judge King has aptly described, the fact that his firearm could easily have reached the officers and killed the officers. We might talk about what might have happened, but part of the totality of the circumstances are those circumstances with which the officers were confronted. And here the material facts are simply not in dispute. They're within the line of fire, for goodness sake. The officers have heard the gunshot, or what appeared reasonably to be the gunshot. They disregarded the commands. They were shooting out of a front window. This is not the kind of excessive force case we have heard before, because they don't involve an active shooter who is actually firing something that looks like the kind of firearm that Judge King has described. And what Judge King described was not a toy gun. It was a lethal weapon. And the officers were within range of something that was, whose lethal capability, to use the summary judgment, was not in genuine dispute. And you come at the end of the road to that, and one can debate the ins and outs of mental illness, but I don't think that the fact that one can debate that is sufficient to defeat summary judgment, where the facts right before the officer's own eyes gave them a reasonable belief that their lives could be terminated. That's what those facts are not in genuine dispute.
Agreed,
Those
Your Honor.
facts included the fact that he actually had a second gun.
That's correct, Your Honor.
That's right.
Unless there's no further questions, I'll take my seat. Thank you, Your Honor.
Thank you, Your Honor. I just want to start with the ADA claim that we finished on. My friend on the other side said that Waller supports their position that the requested accommodations are novel. But in fact, Waller sharply illustrates how the city's response from the beginning on the mental health accommodation was deficient. In Waller, unlike this case, circumstances were exigent from the beginning. There was an active hostage situation, a man holding his girlfriend hostage at knife point. And yet, in those 2 hours...
Did his mother sponsor him carrying all these guns and dressing up like a cop and having an ID for a policeman?
No, his mother ensured that he did not have a real gun, and
He had a real gun. He had 2 guns.
this was not something that she had ordered or sponsored
Well,
of him.
He had a holster to put it in. He had ammunition that fired and made noise, big noise. And the mother is the plaintiff here.
She stated at deposition she was not aware he had purchased this gun, and he had apparently got it online from a store that sells prop guns. Returning briefly to the ADA claim, in Waller, the city there actually brought in a hostage negotiator to speak with him. Here, by contrast, the only officer who had mental health training on the scene, Officer Tilson, spoke with him for 30 seconds, watched him drop the gun before leaving, and...
Excuse me, I think the point is being made that it's really not entirely fair to sort of load on the officer's shoulders that, there might have been a prior arrest. Well, there may not have been, they may have been, I don't know. But the point Judge King makes seems to me entirely valid, that one of the things that contributed to the situation is the mother's relationship with the son and the mother's desire to either give him a weapon that would mollify him or whatever. But that's part of the totality of the circumstances here. And whether one looks at the officer's prior arrest or non-arrest or whatever should have been, or whether one looks at the mother's conduct, but none of it changes what the officers were confronted with an active shooter who had them well within their line of fire. That's the point.
Judge Wilkinson, setting aside the officers on the excessive force claim, the ADA claim begins at the beginning of the interaction when officers Tilson and Ellis arrived on the scene. And at that point, it was not nearly an active shooter situation. It was Bobby who called 911. Officer Tilson, who had previous experience with him, did not believe that he was acting out of the ordinary and thought he could resolve the situation on his own without calling in backup. Officer Tilson and Ellis allowed him to drop the gun without taking it away from him. And then the only officer with specialized mental health training went to chat with the neighbors for 10 minutes, as opposed to trying to talk him down from his maniac phase, as Judge Gregory discussed previously with my friend on the other side. Starting from the beginning of that, officers did not provide basic accommodations that officers in cases like Waller did, where in Waller, they brought in specialized hostage negotiator. They repeatedly tried to contact the individual who was holding a hostage, And they tried to contact other family members to try and come up with a way to address his mental illnesses before the situation got even further out of hand, and only then use lethal force. Officers Tilson and Ellis could have done that from the beginning here, but the fact that they did not means that they did not attempt to accommodate Bobby's mental illnesses under the ADA. For these reasons, we would ask that the court reverse the grant of summary judgment or at minimum vacate and remand on excessive force. Thank you.
Yeah. Bob, have you, Roger, do you have further questions? We thank you both. We'll adjourn court and we'll come down and say hello.
This honorable court stands adjourned until this afternoon. God save the United States and this honorable court.